Hi, Wes Scott from Kane and Scott. Today we're going to talk about who are the major players in a Chapter 13 bankruptcy and what do they do. You cannot have a Chapter 13 bankruptcy without somebody who has debt, and that's a debtor. Of course, a creditor is somebody that you owe the money to. A creditor is anybody who claims that you have liability on a debt owed to the creditor. And then there's a debtor's attorney. You always have representation in this. I cringe when I see people trying to represent themselves in bankruptcy. It's complicated, and you can materially impact your rights if you mess it up. Always, of course, call local and licensed bankruptcy attorneys, never anybody out of state, and never paralegals. They're not licensed. They can't give you legal advice, they can't quote you fees, and they can't retain you. You have creditors' attorneys. Creditors' attorneys, of course, look out for the interest of the creditor. In the bankruptcy case, very rarely do creditors appear at the meeting of creditors. It's very rare. The vast majority of meetings occur without creditors present. But that doesn't mean the creditor's attorney couldn't be communicating with your attorney. They might. But even that is rare. And then you have a Chapter 13 trustee whose job is to administer the payments that come into the estate, make sure that they have a clear financial picture of the debtor, and that the debtor's plan complies with the code requirements. And then you have a bankruptcy judge who, of course, decides disputes amongst the parties when they arise. When you are ready, reach out to Kane and Scott, Minnesota's highest Google-reviewed bankruptcy law firm. You'll be so thankful you did. Have a good day.